Now that's certainly something that you could attack on cross to show that he didn't do it himself and he's just relying on other people. And it might be a grounds for a hearsay objection, but on the objection as stated, overruled. So this document will be admitted. Is there any objection to that document?
Your Honor, that is not one of the specific documents that passed up. It is the checklist that is associated with those documents.
Okay, I'm confused. Clarify.
That's the checklist they fill out while they're performing that report.
Okay, but so opposing counsel in attempting to introduce this document?
That specific document, no, but that document is associated with those documents.
All right, let me see the actual documents that are attempting to be entered.
If I may approach the bench, Your Honor.
And what, your objection to these is just because of the fact that it relied on this other
Relied
stuff?
upon the methodology, relied upon the procedures outlined in the checklist, and therefore those reports are inaccurate because the checklist was not correctly followed.
All right. Putting this completely aside, just the information on these two documents, is there just the information on the documents he's attempting to admit that will go before the jury? Is there any information on these that you would object to?
Right. Or, Conde,
Yeah, sorry.
Your Honor, the methods relied upon to reach the conclusions in these reports, the methods were not followed accurately, therefore the reports are inaccurate.
All right. The reliability of this testimony is something that you certainly can attack in cross, but if there is nothing that violates a rule of evidence contained in the documents themselves, I'm going to allow them in, and then on cross, just bring out these inconsistencies. Okay? So, overruled. And these two are admitted.
Your Honor, maybe,
His time.
or like,
Oh, yeah.
May I continue? Dr. Smith, after you ran the test, what was the blood alcohol of the defendant's test?
The blood alcohol content of the defendant was 0.19.
Now, Dr. Smith, is 0.19 blood alcohol level a significant number?
Absolutely. A blood alcohol content of 0.19 is over twice the legal limit.
That is all we have at this time, Your Honor. Permission to approach witness?
You may.
Permission to approach bench?
For what?
Tender this into evidence.
Are you ready to cross examine?
yes, Your Honor. May I proceed?
Yes.
The director of the Midland Center Department of Forensics, correct?
Yes.
And it is your responsibility in that role to create procedures that breath test operators are supposed to follow, correct?
Yes.
And this is to ensure the validity of the breath tests, correct?
Yes. For the results to be valid and to a satisfactory level.
Okay. And if those procedures are not followed, if those operating procedures are not followed correctly, the results would be unreliable, correct?
If they were not followed to a satisfactory level, they would be invalid.
So if they were not followed, they would be unreliable.
if they were not, if it was found that they weren't followed to a reasonable level, then they could be found invalid. Yes.
And these procedures, each and every time they're conducted, the same procedures are always followed, correct?
Again, you can never be certain that they will be followed perfectly. You can only be certain that they will be followed to a satisfactory level for them to be proven valid. Yes.
So every time the test is run, the procedures are performed.
Yes.
Okay. This is to ensure, there's an observation period in this, correct?
Yes.
This observation period is to be conducted by the operator because the operator is trained in what to look for, correct?
That's incorrect. The procedure only outlines that the operator is certain that the observation period was allowed.
But is it not the operator checklist?
Yes, the operator is supposed to fill out the form, but nowhere in it does it say that the operator has to allow the observation period, has to perform the observation period.
Who was operating the Intoxilizer 8000 on the morning of September 25th?
I was.
And so you were the one who was supposed to be following the operational checklist, correct?
Yes, which I followed.
So, only trained operators perform these tests, correct?
Well, only trained people are allowed to fill out the reform and perform the test, yes.
Okay. And this is because if you're not trained, you don't know the test, correct?
You don't know how to operate the Intoxilizer 8000. So it's not necessarily that you don't know the test, it's you're not allowed to perform the test because we can't be certain that the results obtained would be valid.
So most officers aren't trained in how to perform a breathalyzer test, correct?
Yes,
Objection, Your Honor, outside of scope of expertise.
Overruled. Yeah.
In fact, on the night and early morning in question, you were the only operator, the only trained operator in the station, weren't you?
Yes, I was.
And that's why Officer Foster called in to make sure someone would be there, to make sure you would be there to perform the test.
That's correct.
Now, when you performed the test, you followed your operator checklist that you created, correct?
I followed it to a satisfactory level. Yes, I did.
The first item on the operator checklist is the pre-test observational window, correct?
Yes.
That's where the trained operator observes the person being tested, correct?
Could you repeat the question?
That is where the trained operator observes the person being tested, correct?
That's where the trained operator fills out the form, very certain that the observation period has been allowed.
Isn't the test not about filling out the form, but actually performing the test and observing the person in question?
Well, this is the part of the test. It's the pre-observation part of the test. It's to ensure that an observation period has been allowed.
So what you're saying is that you relied on Officer Foster to perform part of the observation window, correct?
Yes, I did allow. I allowed Officer Foster's testimony that he observed the defendant for 20 minutes, in excess of 20 minutes. Yes.
So how did the officer get from the scene of the accident to the station?
I believe they drove.
So are you aware of the conditions on the night?
No, I'm not.
Are you aware of Canyon Road?
No.
You've been living in Midland Center for however many...
Objection, Your Honor, relevance of these questions.
It's definitely relevant, but he's, well, how is it not relevant?
Whether or not he knows Canyon Road, whether or not he knows the condition outside at the time do not go for or against the truth of the matter asserted.
It does, Your Honor. It goes to whether Foster is reliable as an observer.
All right, how so?
Well, Your Honor,
What is this gonna show?
I'm going to show that Foster was attempting to drive and was not able to observe Dan.
And your response to that?
I believe that the officer would have been very much able to determine whether or not Ms. Dawson consumed alcohol in the back of his car, whether or not she had mouthwash. I believe that even while driving, the officer was able to monitor the person to a sufficient extent.
Your Honor, one of the issues, the whole observation window's purpose is to ensure that mouth alcohol evaporates. One of the things that contributes to that is can be gastric events, including heartburn. If Officer Foster was attempting to drive on a dark, rainy night on Canyon Road, he could not tell whether or not Danny had heartburn during that drive.
And another gastric event that can dramatically affect the outcome is a burp. It would definitely be relevant whether or not Officer Foster thoroughly observed the defendant. So you can attempt to lay foundation of distractions, and then at that point it'll be up to the jury how much weight they give the testimony. So overruled, although we really haven't answered any of those questions yet, but you can continue down that road for a little while.
Okay. So, if it was dark and rainy, and if the road that the officer was driving on were to be considered a dangerous road, what would you think about, wouldn't that cause a distraction for Officer Foster?
Objection, Your Honor, speculative.
Your Honor, it's a distraction, it's not safety.
Here's how that we're going to address this. Sustained for now. Ask the witness hypotheticals, because he can give his opinion in that form. But keep them one fact at a time so that it's easy for the judge and the witness to follow along.
Dr. Smith, hypothetically speaking, if you were driving on a dark road at night, wouldn't you be distracted?
No.
Or rather, wouldn't you be concerned with the road conditions?
I would be concerned with the road conditions.
And if it was dark and raining on a dangerous road, wouldn't you be concerned with the road conditions?
Yes.
So, if Officer Foster, rephrasing. You relied upon Officer Foster, correct? In your observation window?
Yes, I did rely on Officer Foster.
Before he got to the station, he was on Canyon Road, correct?
I do believe so.
Okay. No further questions, Your Honor.
All right. Any redirect?
No
All
redirect.
right. Here's how you address that. Yeah, if you want to.
Oh, really?
Yeah.
Sweet.
Objection, Your Honor, this is against.
Dr. Smith, if you were driving on a road and it was wet at night, what would your attention be?
I would be, well, it depends on what I was driving with, but if I was driving, I would be focused on the road.
That's right. Your eyes would be focused towards the road, wouldn't they?
Yes,
And typically when an officer takes someone into custody, they place them in the back seat. Isn't that correct?
I do believe so.
So if Officer Foster wanted to look at the defendant, he would have to turn around and physically look at him. Isn't that true?
Yes.
So he'd have to take his eyes away from the dark, dangerous road. Isn't that true?
Yes.
But you admit that if you were under the same circumstances, your main attention would be on the road. Isn't that true?
Yes.
And not behind you. Isn't that true, Dr. Smith?
Yes.
Thank you. No further questions. That's all you have to do. You have to
Here-
focus where his eyes were.
And not only that, once you get the information out, and not just with this, just in general, all new attorneys, they want to ask the wrap-up question. All you have to do is get the information out, and then the jury automatically is thinking it. You don't have to, get that final wrap-up question in. All right, direct. Watch out, you called the defendant a male a couple of times, or he, and you called it too. And then both of you, it doesn't matter so much because you're, a doctor who performed this test. You kind of referred to her as Danny Dawson and the defendant. You did too. You always need to refer to her as the defendant. After the defendant did this, after the defendant did that, not after Danny Dawson